Welcome to the program. This is a big topic, the future of the estate planning profession. I can tell you that I have not been more excited to hear a discussion than this one in a very long time. Um, Jonathan Blattmachr gave a presentation at Heckerling in 2010, 2011 that talked about the future of the profession, not to, extol him, but everything he said came to pass. And when I went home, I had drank in the Kool-Aid at his lecture and immediately, like the next day, started planning how I was going paperless. And that was like a lot of years ago. And I think well ahead of when most people went paperless. Cloud-based everything. Alan Rothschild and Lou Harrison are brilliant practitioners and nice guys. I didn't say that about you, Jonathan, sorry. And I've heard them lecture just incredible insights, and they both think out of the box, which is what this topic is about. Before we get officially started, we're going to have a quick announcement from Teresa Bush of ILS Interactive Legal about ILS, and then I guess, Jonathan, you'll make a quick comment on behalf of Peak Trust.
You bet.
Okay, Teresa, it's all yours.
Great, thanks, Marty. Yes, Interactive Legal is pleased to sponsor today's webinar, and of course, we'll have it up on our website so people can watch it later. I'm the Director of Education for Interactive Legal, so whenever there's a webinar, it's always of interest to me because as an estate planner myself for many years before joining Interactive Legal, the hot topics were always what I cared about. And way back then, back in the 90s, we thought that we were moving toward the future of law practice and drafting estate planning documents when we had fancy word processing merge forms. But of course, we're much farther along now, and I like to think that Interactive Legal is a big part of that because we can do way more with software. Now it's online. It's not just software. It's an app online, so you can get to it anywhere, cloud-based, like you said, Marty. But you can do so much more than what we could do back then in the 90s with the merge forms by building in options and, just making sure you're staying up to date. So I'm really looking forward to today's presentation because my focus is on the document drafting piece, and there's so much more.
Jonathan, quick comment on behalf of Peak Trust.
Well, Peak Trust is honored to sponsor this. Peak has always tried to remain in the forefront of what's going on in the profession. It provides a complete complement of services in the trust industry, and it's adding more on. As we will discuss, the services which the trust industry is offering is expanding, and Peak is really part of that. So if you want to be with folks who are right at the cutting edge of it, call somebody at Peak.
So in my career, I've never seen a time where there's been more change, more uncertainty, more going on than right now. It's both exciting and worrisome. The first topic, and Alan has suggested we limit the discussion of this to 20 minutes because we could easily consume the entire program with just this, is AI. And I just want to share something that I think I figured out yesterday, which is a very interesting and odd application of AI. We get inquiries all the time from prospective clients, and something just seemed a little odd about the tone of some of these inquiries. And we put together like 3-4 of the recent emails that we've gotten. And we believe that people are starting to use AI to draft the inquiries they're sending to us as an estate planner, because the cadence and the terminology starts to look very similar. It's very odd. And instead of the people like they used to telling you kind of little about who they are and what they want, it's this sort of computerized version of it, which is makes it much harder to understand what the people are really looking for. But AI, I know, Jonathan, I'm going to let you start because I know you're anxious to talk about it, and then Alan and Lou can jump in. What's AI doing to our profession? Will we have a job next week? Are we all going to be at the beach or fishing with Alan?
Well, Marty, this is, as you say, a tremendously exciting and yet frightening time. The concept of artificial intelligence has been around for literally decades. And a lot of the things that have happened, which you can say relate to artificial intelligence, have reduced the burden on us as practitioners. We no longer do 12 or 15-page instruments. We now do 100-page instruments and don't think anything about it. But whether or not there's really going to be artificial intelligence or not depends upon, of course, how you define it. There are some great futurists like Jeff Glickman, who's a friend of mine, and some of you have heard Jeff talk about this, and others like Ray Kurzweil, who wrote a book which had a profound effect on me. He wrote that in 1999 called The Age of Spiritual Machines, where he talked about how some sort of artificial intelligence would actually be able to think. Now, Jeff tells me that even though there are forecasts that we will have artificial general intelligence, which is intelligence produced by a being, basically a computer system, that will be smarter than any individuals who have ever lived on the face of the earth. You know, you can say who's the smartest ever, whether it was Isaac Newton or Leonardo da Vinci. That won't matter because this being will be so many times smarter than that. But Jeff tells me that no one is even within 5 years of that, even though I saw something on 60 Minutes a few weeks ago that said it could be here in a year or two. Jeff tells me it's not going to happen. The large language models like ChatGPT, which we've all seen, don't really have the ability to think, but they can do a lot of what we would call rudimentary things like, searching for something and getting an answer. You've all used ChatGPT, and if you haven't, you better get with it because it will really change how you practice. Understanding that these systems now don't think on their own. They merely go out and search for what they try to find is most likely to be what you're interested in and then parrot it back. One of the things I've done, and I'm sure all of you have done, is you ask the same question basically 2 or 3 different times in 2 or 3 different ways, and you may get entirely different answers. And that means that the system is not working perfectly. And as you also know, there are lawyers who have been admonished, some have been fined by using some sort of large language model like a ChatGPT system in order to prepare part of a brief. And the system has no morals. It will lie. It will do whatever it thinks it has to do in order to get you where you want to be. But I think that that is going to happen more and more. In fact, forecasts are that there was something in the New York Times the other day that basically the ability to have an entry-level job, whether it's at Morgan Stanley or whether it's at Goldman Sachs or whether it's with an accounting firm, those jobs may basically be gone because the rudimentary work that those people would normally do would now be done by computers. I just see it as having a tremendous impact. Now, there will always be people like the people on the phone who are extraordinary experts. And until you have a computer that can actually think and reason, and none of the systems does that now, none of them does that. There's going to be a place for us human beings, at least for a while. But I think in 5 or 10 years, it may be, as Marty said, we'll be told, just go to the beach. We'll take care of it all. And that raises such profound questions about how do you share what computers are doing. Ray Kurzweil believes that around 2050, computers will provide us with everything that we need, our food, our air conditioning, our cars, our movement, everything will be done basically by computers. And they'll be so much more talented and quick than we are that we just can't compete. Some believe that's very good, some believe it's very bad. But right now, you want to make sure that you are at the leading edge of these things so you don't fall behind. Because if you fall behind, you're not going to be able to compete. Now, let me back that up with a however. However, people like dealing with people. And until you have a computer system where you really can't tell whether you're dealing with a computer or really a live human being, I don't think there's that much that you have to worry about entirely. But Alan, what do you think? What do you see the next movements in artificial intelligence to be?
I'm not spending a lot of time studying it, but I'm really excited about the possibilities. I realize that as some of the other technology that we utilize in our practices, whether it's the expert document drafting systems or the mathematical calculation programs that calculate our GRATs and CRTs for us, I found that in a small to medium sized law firm, it actually helps us be more competitive. It used to be if you were doing tax calculations that only the large accounting firms and large law firms had the very expensive software to do that. That became very affordable. Interactive Legal allows a 20-person law firm to have access to expert forms and knowledge that a 500-person law firm 20 years ago would only have. So I see AI as a way to make many small and medium firms more competitive in the interim period of time. I don't know what's going to happen 20 years from now. There may be AI avatars doing what we're doing right now, but I think for the next couple of decades, AI is really going to give firms like ours opportunities just like some of the earlier technologies did.
Lou,
How about you,
are you,
Lou? What do you see?
Lou,
So,
before you start, is this you or an avatar?
I'm hoping it's an avatar because unlike Jonathan, who likes to deal with people, what is it? People like dealing with people. I'd prefer for my avatar to deal with people. That sounds a lot better to me. Jonathan, I agree with most of what you said. Never all of what you said. Number one is we have so much information and the speed of which communication is expected is increasing that AI is just one more addition to the ability to obtain information overload for us as planners, clients, and so forth. And learning AI is one more piece of the puzzle for us in a day that's already somewhat over scheduled. So when you look at AI as a planner today, what do you have to do? Well, here's one thing you're going to have to do. It's here to stay, and it's going to be useful. So you're going to have to begin to understand how you can use it. You're going to have to try it. You're going to have to understand its limits. You don't have to, and this is where I disagree with you, Jonathan, just a little bit. You don't have to be on the leading edge yet, because a year from now, 5 years from now, the refinements in AI in terms of how it's going to apply to what we're doing are going to be so substantial that it will be a lot easier. So I wouldn't commit, and again, just my bias, I wouldn't commit the effort not quite yet to be on the leading edge, but I would commit the effort to understand how to use it. In terms of what it's going to do for our practice, keep in mind the following. If you go back over the last 40 years, or in Jonathan's case, the last, say, 80 years of practice, technology changes have occurred, maybe not as fast because we're really rising a little bit more exponential than we used to, but technology changes have occurred throughout our practice. And the bottom line is all that's done is made us more useful, more competitive, more needed for our clients, more value to our clients, and it's increased the practice and the revenue. So every technological change, including the ability to draft complicated documents in a much more efficient way, as Alan mentioned, has been beneficial to us. And AI is going to be the same. It is going to absolutely increase the speed of which we're practicing. It will increase our revenue, but it will not replace us for the simple reason, one, where I agree with Jonathan, it's not a rational thinking animal quite yet. But here's the reality. Our clients are irrational thinking beings for the most part. So we all know that behavioral finance and the inability to always have the rational answer is a major part of our clients' decision-making process. That's where we have to step in to get them to do what we know they should do, but they're sometimes incapable of doing that. AI is going to have a hard time replacing that that's probably 10 to 20 years out for sure. So I'm excited about AI. Going back already to your original lead-in, I think it's going to be great for the profession. Dabble your toes into the cold water, and shift it back to you, Marty.
Let me just make a couple of quick comments, and if any of you want to comment on what I say, if not, we'll go on to the next topic. I just want to give some specific examples of how we are and are not using AI. So we tried some subscription services to transcribe web meetings that we have, and it sounded really promising. They give you a summary, they give you a transcription, great. And the thought was, golly, we can take the summary that AI generates from a web meeting and use that as the starting point for a letter to the client to just follow up. It would make it more efficient to do a letter. Suffice to say, I'll give you a quick example. I gave a presentation for an estate planning council in Boston and asked how many people use AI to transcribe meetings, and only a few hands went up, like 3 or 4 out of like the whole room. And one of the people said it was great. A couple of people said it was really great. They use it. One of the financial advisors said that their last meeting that they had transcribed, the summary somehow said that the advisor was planning on marrying the client. Like, off the charts crazy. I have found that with the highly technical nature of what we do, and echoing Lou's comment, the very personal, tailored human aspects of what we do, that the transcriptions and especially the summaries miss really key stuff and get stuff way wrong, way wrong. So what we do is we still transcribe meetings with clients' permission, and the AI says, hey, we're going to transcribe this, click OK. But what we do is we still take notes like regular people, like we always have. We use the AI in case we miss taking notes about a particular point or if we want to refer back to, but we don't even use it as a starting point for a letter because we've just found it too inefficient. Another application of AI, writing an article, it was always tedious, especially, I don't know if everyone on this call is too young to remember when we used to have to get books and look things up, but AI makes it really efficient and quick, easy to get statistical data to support something. So if you're writing an article about the importance of divorce and slat planning, you can really quickly just ask AI, get me some stats on divorce, and bam, bam, they give them to you. You still want to check them, but it's faster than asking somebody in your office, a staff person, to go get you data. It's like, bam, it's right there. So for non-tax technical information, it's been very good. We've tried having AI write articles for materials. It's suffice it to say, we don't even try that yet. Maybe in some number of years that'll be better. So there's some really great things that we can use AI for and some things we can't. Let me tell you the most powerful thing, which I find amazing, and a quick caution. Make sure you have a subscription service to AI. You're not using a free version, because the free version is going to send your client data to the cloud for machine learning, not what you want. AI, we use ChatGPT, and all of our data, our files are in the Microsoft Cloud, SharePoint. When I ask AI a question, it searches every client file as well as the internet, and the first segment of responses tell me what was in my database. The second set is what it found on the web. This is incredible. We started scanning due to Jonathan in like 2011 or 2010, whenever he spoke at Eckerling on it. Every article, I used to have, like many of you may still have, file cabinets full of articles and journal articles and memos and speeches. All that stuff was scanned when we went paperless. It wasn't really accessible. You could search in NetDocs or something. It wasn't great. It was very tedious and time consuming. Copilot, Microsoft's AI, searches the 500,000 documents that we have in the Microsoft Cloud. I was trying to find something on a particular topic that I was researching. Didn't even remember. It found a speech I had done like 15 years earlier that had the information in it. I could never have found that. So I think the broad picture that Jonathan, Alan, and Lou painted is really fascinating and interesting. but I think there's applications we can be using now, and there's some that we want to really be careful of. Any comments or thoughts?
I have a question for the group. I think it's really beneficial to have summaries of calls and meetings on AI as the starting point internally for us. The two concerns, though, I've had, Marty, you mentioned the privacy issue, which is an ethical issue. So I'm not quite there on the privacy side on how private this information that is being recorded achieves, even when you check the box. I'm interested in everyone's opinion. Second is when we're drafting documents, all of a sudden having voluminous notes sitting in the file that someone else created, when in fact I want the end document to speak for itself, is not an item that I have currently in my files, and not an item I particularly want in any files going forward on estate planning documents. So in other words, I'm a little worried that we're going to have sort of over inclusion on documents with AI than what we really want to have at the end game. So
That's a very interesting point. That makes a lot of sense.
Let me also mention, consistent with what I think we've all been saying, is that it's not just the ability to run numbers more efficiently to tell you, well, if you do this kind of trust, or you do this kind of transfer, you're going to get a certain result. Human beings are very individualistic. And even though we might say, well, I know what all my clients should do, they're probably not going to accept that. And so you're still going to have individual likes and dislikes on what people want, and you've got to cater to that. And I think that will take quite a while for artificial intelligence to catch up and exceed our ability to do that for our clients.
So let's go on. If everyone's okay, we'll go on to our next topic, and we'll go in the reverse order. Lou, Alan, Jonathan. Declining importance of the estate tax. I'm assuming we're going to have a $15 million permanent exemption. I acknowledge that the word permanent when it comes to anything tax related is only until it's changed by another administration. But it's clear that the estate tax exemptions are dramatically higher than probably any of us could have wildly imagined only some years back. Lou, how do you see that changing the profession? What do you think it means?
I think it actually means more opportunity for us, Marty. It's interesting when I tell third parties who are not lawyers, what do you do? And you say you're an estate planner. They say, oh, you draft wills. And, when you say another lawyer, what do you do? You're an estate planner. Oh, you reduce estate taxes. What we do in the profession is so expansive that estate tax, if you told me estate tax counts for 5 or 10% of the revenues of an estate planning group, wouldn't surprise me. We talk about creditor protection, spousal protection, how to achieve purpose and productivity, one of Jonathan's key themes, which is true in future generations, what the wealth means charitable, how to solve for kids that have difficult problems, marital problems, and we could go on and on and on. I think the reduction of estate tax planning is helpful in increase of credit. I think it focuses us on clients' goals that are really important to them. Trustees of trust, items that we might give 5 or 10 minutes to in a discussion, we'll give an hour to, because these are critical items for clients. So I think it's going to increase the value we as estate planners have for our clients. I think it's going to make us busier than we are currently, which is a problem. We'll come back to that later in the discussion, but I think it's all positive.
Alan?
I think we fell into the same trap over the last 4 or 5 years that we did before, pick a year, 2010 or 2017, when the exemption went up. We spent so much time the last 3 or 4 years telling people that the sky is falling down and they had to utilize their exemption, or at least make an affirmative decision not to use the exemption before the end of this year. And it appears that the elections last November changed the future of the estate tax exemption direction significantly, or brought clarity to the issue, it would appear. It was refreshing to me to finally have to tell clients that there are other reasons to put assets in trust for their spouse and their children. Jonathan has been preaching for as long as I've known him, never leave anything outright to anybody, leave it in trust. And I thought that that was great advice for your billionaire clients. And I don't have too many of those, but I start thinking about that and realizing what great advice that is. I had 2 clients in 1 year in their mid 80s go through divorces.
Mid 80s.
And we've seen the stats that there appear to be more wealth lost to creditor claims than to estate taxes. And so all of us probably had clients who needed to use their exemptions up. And then as soon as the November election results were clear, the clients didn't want to talk about it anymore. And I had been, if you've got a $50 million client, they're going to be subject to an estate tax with exemptions $7.5 million or $15 million or whatever. And we all know the reasons they need to do lifetime planning, lifetime giving. And as soon as the tax reason went away or was delayed, they stopped thinking about it. And I've tried to tell our clients they need to do the planning. We're back to what we've always talked about, even in a stable tax environment. You've got what appears to be a taxable estate. Give what you are comfortable giving as soon as possible. But what I'm seeing is that asset protection planning is moved up to be a #1 topic. And that's protection from the possibility of divorce, business claims, the behavior of our 90-year-old widowers. Protect those assets for the primary beneficiary, but also for the secondary beneficiaries of the trust. And then, of course, income tax planning. I mean, I bet we're all spending as much time thinking about the income tax aspects of our estate planning client situation as we are the estate tax situation.
Jonathan?
Well, what Alan just said is so true, that we may no longer focus as much on estate tax, although, of course, there's a reasonable chance that it will come back with a big bite in the future. But a few years ago, I wrote an article with one of my most brilliant colleagues, Madeline Rivlin, entitled "Searching for Basis in Estate Planning." And we pointed out, of course, with then a $5 million exemption, much less, 15 now, that rather than focusing on getting assets out of the estate tax net, you want to maybe keep them in the estate to get a step up in basis. That's critically important now. In fact, only 2 in 1,000 decedents will have any estate tax. And even if you've got just a smidgen over whatever the threshold is, 15 million, and of course it's going to be adjusted for inflation, you still need to think about basis, and that's going to be an important factor. Whereas before it was make sure there was no estate tax. Now you want to make sure you get in the estate, even if you have to pay a smidgen of estate tax, in order to get that income tax-free step up in basis. And as many on the webinar know, I've done with my dear friend Mitchell Gans a lot of work in the area of trying to get an increase in basis when someone dies, even for assets that may not technically be in the gross estate. But that's something that almost every client will think about and worry about, including the surviving spouse. So, you're not going to pay any estate tax, but you want those assets in the estate. But as Lou and Alan both have indicated, you still want to have those assets in trust to protect them from claims of creditors and foolish dissipation. I mean, the divorce rate is still about 50%. And as people live longer, I think that percentage may well go up. So, there's still grounds for having a complicated estate plan devoted to tax matters. That's going to continue. I think it will continue for a long, long time.
I agree with everything said. Let me just add a few really quick comments. To reinforce what Alan said about protection planning, more money is lost every year, and most of this can't even be estimated, to elder financial abuse than is lost to estate tax. We as a profession, I don't think, do nearly enough to help aging or infirm clients really protect their assets. It's not just about trusts, it's about all the planning and coordinating the planning and a whole lot of other things. I think one of the problems that was said, I'll just say it in a different way, we as a profession, I think, sent the wrong message for the last 3, 4, 5 years. The message to every client was use your exemption, because the sky is falling, exactly as Alan said. And a lot of those clients didn't really need even to do it, but it diminished the importance of all the other really important things we do. And I think we need to work as a profession on better messaging to clients, because Lou went through, there's so many important things that we do that are so much more complicated. Dealing with family dynamics, I don't know that there's anything more complicated that we ever deal with than that. And it's really, really important. Interesting comment on asset protection. And now I'm rethinking a little bit, because that's how we learn in terms of AI summaries. What clients say on a meeting about, I just want to protect my assets. All I want to do is protect my assets. You probably don't want that in your file. So I'm going back to Lou's prior comment on this discussion, and I think that could be very important. The one thing that concerns me is tax is like a sanitary, easy thing. I don't want to pay tax, I'm going to a lawyer. Much easier to motivate somebody because there's a tax threat to do planning than, my kid's a ne'er-do-well and they're just wasting money. They're never going to launch. I got to go to a lawyer and plan better. It's much harder to deal with those personal, emotional issues, and a lot of clients can't verbalize it even to themselves. So the tax, I have found, has been a motivator, the estate tax fear, for all the other work we did. And the one concern I have is clients that really need our help may not come for help because they're going to get a simple answer either online or from a financial advisor to a problem that they really need somebody that's been doing this for a lot of decades in our seats as specialists in this field. So I think we can go on unless anyone has the last word to the next topic. Competition. I know, Lou, you were going to comment about accounting firms buying law firms yet again. So maybe you can lead that off, and then we'll see what Alan and Jonathan have to say.
Well, I think as everybody on the call knows, there are estate planners, and then there are people that are doing estate planning. And I think the reality is our field is sufficiently complicated that you're going to need high-level, full-time estate planners of some notoriety, for lack of a better word. And the competition that's brought by accounting or other firms buying in-house legal staff to provide some type of stickiness for their clients via estate planning ideas, and we'll come back to the financial institutions. That's been there for 40 years. That's a annoyance, but has not been an impediment to the practice, and I still don't see that being an impediment going forward to the practice until somehow law firms in a more realistic way than currently can be bought by third parties. And I don't know, Marty, if that's an issue or an item you want to go down during this call, but that could be a problem. That's not there yet. So I think it's out there. I'm not worried about the impact that's going to have on the estate planning profession.
Well, I am a little concerned about it, Lou, for a couple of reasons. One of the things that happens is that, others that provide services, be they accounting firms or banking firms or asset management firms, they now advertise that they can do it all, including your estate planning. And in my experience, there's great variation in the quality of people who offer estate planning services. But I still think that lawyers, basically in private practice, could do the very best job of providing that. But of course, if you have, the same person working for a financial firm who would be offering it in a private law firm, maybe that really doesn't matter. But right now, the ability to say, well, you can't do that because that's the practice of law, I think that's largely gone. So I think you will continue to see basically competition, not so much from other lawyers, but from people in what I'll call collateral industries like accounting. And I think, Marty, you began by pointing out that there are now accounting firms that have hundreds of lawyers doing estate planning work in-house. And, they feel very comfortable in doing that. They don't feel that they're engaged in the unauthorized practice of law. And I'm not sure that the bar is trying to stop that at all, for whatever that is worth.
Hey, can I add one comment, Jonathan, to what you said? The part that I didn't mention is I think any estate planning practice that we're engaged in should have and should continue to build a trust and estate litigation component, because basically what's happening with these, I won't call them mills, but what's happening with these ancillary practices, they may be doing it, but for the most part, they're not doing it at the level you mentioned and at the level that's correct. All that's going to do is increase the amount of trust and estate litigation, tax controversy work, and other related litigation. So, and it's also going to have a lot of clients coming back to you to fix a problem created by somebody else. The cost to fix a problem is 10 times as much as the cost to do it right to begin with. So again, I don't think that competition is going to hurt our practice.
Alan?
Alan, what do you think?
Well, I think you may want to go into fiduciary litigation, because it seems like to me there are going to be a lot of conflicted interest issues if you have these affiliated law firms that are preparing documents that perhaps name the affiliated entity as the fiduciary in those documents, for example. I remember when the Merrill Lynches of the world started offering some estate planning services, and one of my mentors went bananas. He just could not believe they were stepping into his space. And I was brave enough as a young lawyer to say, look, you can't compete against a Merrill Lynch initiative. You need to figure out a way to work with these folks. And I have found that many of the financial institutions and wealth managers are the greatest source of business for our practice ever. And the shift in the work that's been done in the traditional bricks and mortar trust companies affiliated with commercial banks to the fiduciary services that are affiliated with wealth managers that don't have the bricks and mortar banks it's just been incredible. But what I found I've got to do is to try to figure out, are these the kind of folks that want to bring, that are educating the client in a good way, and then connecting them with a lawyer who can review the options and understand the client and recommend what might work for their needs? Or are you simply being hired to be the scrivener? And I don't think we want to get into that scrivener role. I mean, forget about the dollars and cents side of it. That's a terrible role to be in. I can't stand it where you never have a chance to talk to the client, that you're always going with the wealth manager intermediary. I've talked to Mrs. Jones. This is what she wants. Will you prepare this document for Mrs. Jones? We can't be lawyers. We can't exercise our professional skills in that type of relationship. But it's wonderful to have a well-educated client come in. They're motivated because of what the wealth manager has told them about taxes or asset protection planning, or updating them on where the law is going, or introduce them to a GRAP or an installment sale. But we still have to have the ability to do what we're good at doing, exercising our independence, communicating directly with the client. And it's wonderful to have that wealth manager there to review the documents. that's a wonderful additional benefit. An educated client and somebody that can provide input to your documents is a wonderful relationship, as long as you're part of the team, you're a co-equal, and you're not relegated to the room where all you do is prepare documents pursuant to some intermediary's directions.
I, I agree with everything you said, Alan, and I think there's another aspect to that. The liability exposure of
Oof.
not being a lawyer and preparing a document, and it turns out it was the wrong document and the wrong planning. It's very unusual for me to see that when a client first calls me, a prospective client, and asks for ABC, whatever they ask for, it's almost rare that what they ask for is what we end up doing. The problems are always much more significant and much different. They're not what they think coming in. Where wealth advisors are building awareness of the importance of estate planning, that's a wonderful value add if they do nothing else for their client, because too many clients don't want to deal with this and don't. And if their wealth advisor has on their quarterly checklist, talk to them about getting an estate plan, that's wonderful. If the wealth advisor wants to participate and understand some of the plans so they can be aware of it, so they can help with proper administration, like, hey client, you can't transfer money from this trust to here or there, call your lawyer and let's make sure this is right. That awareness can be a huge help. Where I'm worried is that with some of the software products, which are not bad, you have vanilla, FP Alpha, there's probably a whole bunch of the other ones. A wealth advisor can feed all the documents into the AI software, the financial data they already have, the family data they already have, and the software can spit out family trees, balance sheets, recommended estate plans, summaries of all the documents. Now, if that's used to be proactive, if that's used to start a really good conversation with a client, that's great. I'm concerned because I'm seeing some of the people doing this work that they think the software enables them to be estate planners like somebody doing it full time for 30 years. It doesn't. It's a great starting point, but that's all it is. And where they work collaboratively with the accountant and the attorney, that's wonderful, and it's an extra value add to the client. If they usurp that role, which I'm seeing happen in some of the cases, not all, there's good, bad, and ugly, right? And that's an issue. So some clients are going to be really hurt by the process, others will be really helped. And I think that the variation in level of quality is all across the board. What I think is going to eventually bring it back to us, and I am sorry to say it, is where clients are really hurt by bad advice from an advisor who thought they knew far more than they did. They're going to get caught in the litigation at some point. Because if a client has real significant issues and a wealth advisor or an accountant who doesn't have a estate planning background gives that level of advice and the client follows it and doesn't go to a lawyer, I think they're putting themselves in harm's way. So I think there's a great opportunity for the wealth advisory firms to do a great value add and help our clients generate more business for all of us and do a better job. But if it's misused, I think it's going to be very problematic. Next topic. I don't know if anyone has anything to say about cybersecurity.
Well, Marty, that's a huge problem for everyone. In fact, I spent 2 hours on the phone yesterday because I received a call allegedly from a bank where I have some banking activities. And after 2 hours, my secretary and I realized that it was all phony, but it was very, very scary. My nephew, Matt Blattmachr, whom many of you know or know of, has a brother-in-law who is in the cybersecurity division for the FBI. And they do a tremendous amount of work. But, the amount of scamming that goes on to steal money and to steal information about clients is an enormous problem that we have in this country. And I don't think it's being anywhere near as fully addressed as it should be.
Let me just interject a few quick statistics. 39% of law firms that responded to a survey said they had a security breach in the last year. 39%. And of those that had a security breach, 56% had lost client confidential data. This is pretty terrifying. There was one of the comments was about a firm that had paid $8.5 million because of a security breach. Cyber attacks for law firms in particular are becoming more frequent, with up to 40% of law firms experiencing a security breach, according to a 2024 survey. So that's pretty recent. Those are scary, scary statistics. Model Rule 1.8, comment 8 to Model Rule 1.1 says a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. That ain't easy to do. Everything we're touching is changing so fast, so rapidly, and so complicated. I think it's a very, very significant concern that's only getting worse. Alan, Lou?
Yeah, so Marty, when you talk about this, and Jonathan as well, what we really want, so it's a problem, right? Everyone knows it. And what you really want is, you want a best practice. Like, what is our best practice? Is there a consultant that's great? Are there features or our security that we need to have? And it's across the board. So I'm going to give 2 recommendations that are our best practice recommendations. 1, allocate time to this issue. In other words, don't go, yeah, security breaches are a problem. We got some stuff in place. We'll continue to look at it, i.e. tomorrow, and tomorrow never comes. So go to your calendar, start blocking off chunks of time to start committing to this area. And second, same thing, allocate some money to this issue. You have to invest in security. You just have to, and you're going to continue to invest annually in security. So take the steps right now to allocate time and money to this issue, and that's going to be a step in the right direction. Alan?
Yeah, I think in our area of practice, we handle information that would be very embarrassing if clients discovered it was available on the internet or the dark web or wherever you get that type of stuff. And I have spent a lot of time talking to our IT team and our firm leadership about the importance of making sure that we are protecting documents. I think, again, some of the fixes, which might be secure cloud services and things like that, are potentially easier to implement in a law firm of 30 lawyers than they are in one of 500 lawyers. We're very mobile, and if we make a decision we're going to do something, we can implement it very quickly. So I think in smaller firms, while we have to invest in protections, sometimes it's easier to do that and stay current and secure data or whatever than in very large multi-office, even multi-country practices.
Well, Marty, I think you either mentioned to me yesterday or you mentioned it a little while ago, is that there is potential real liability to people in the trust and estates field. It's one I think of when you pick out areas where there's liability for lawyers, trust and estates comes in right at the top. Is that correct, Marty?
From a malpractice perspective, we're one of the highest risk professions anywhere.
Right. And as you pointed out, you really can't do what others do, like accounting firms and banks and others do, which is to just limit their liability. And when you think about it, you hire an accountant.
It's unfortunate. The law as the legal profession should reassess why they're exposing their members who work so hard with such complex areas of the law to unlimited exposure when everyone else at the estate planning table and all the allied professions can limit their liability. And I think that may be a factor explaining the high rates of drug and alcohol abuse amongst lawyers and the high rates of stress. I don't know why as a profession we're not reevaluating that.
Well, keep in mind, this is a continuing problem. And one of the problems is that when someone comes in for estate planning, it's not like they come in and ask you to do a particular deal, a corporate deal or a tax deal, whatever it happens to be, where you do it and it's over and there's going to be a limit on how long you're going to be hanging out there. But when you have someone that's come in for estate planning work and you continue to represent that person, you may be literally on the hook for decades. Even though you say, well, that's old, we did that 30 years ago, 25 years ago. I mean, the timeline outstands for a long time. Now, in theory, and I began to do this when I was in practice, I would send the documents prepared to the client, and in there we would say, this ends our representation of you for purposes of preparing your will, for example. We would love to be re-engaged by you, but this terminates our representation of you for that particular project. And the research I did indicates that that may provide a limitation on time. Whereas with continuing representation of a client on a matter, it may never run out and you're exposed forever from that. And over time, of course, abilities to remember what happened and what was said and why things were done will become so difficult to figure out at that later date.
Sending a letter either saying representation is concluded, terminated, or even just that we've completed all the tasks on this matter, whichever language you want to use, is very proactive, very smart, and very safe. My guess is most practitioners still probably don't do that, and we all should. We should at least try, because you can never get anything 100%. The other thing that can be done is how you set up and monitor your billing system. So for example, if a client came in and doing general estate planning, we can set up a matter, and we do, Jones, Smith, whatever, 2024 estate planning. Next year, we close that matter, we start a new matter, and we get a new engagement letter. So you got to do what you can to limit liability, because the unlimited time horizon of continuing representation is really not, it's a very dangerous thing. Why don't we just segue, since we've already kind of started it, from the cybersecurity? And I just want to emphasize one point Lou said. You got to devote time and money to it. 2 points. I think a lot of firms are very loath, especially at the partner level, to spend time on this. You can't just relegate cybersecurity to an outside IT consultant, because they don't necessarily know how you practice or what's going on, and they may not understand estate planning. So it really does require time. And this is the one thing I agree with Alan, it's easier to be more nimble as a small firm, but the proportionate amount of time and money that we spend as a small firm compared to even a medium-sized firm like you guys is it's out of proportion. But we have no choice because the risks are so great. What about some comments, since Jonathan has kind of segued into malpractice? Lou, any thoughts on the malpractice environment and what practitioners might want to think about and how you think that affects the future?
Well, Marty, it's always been there. It's obviously greater now. It's greater now because of the technology. The amounts are substantial. The difficulty of technical compliance and the ever increasing complexity of the 6 variables that we have to contend with whenever we do one estate plan. I have not found good advice, with one exception. It's something that I'm going back to your comment. You used the word loathe to commit time to security. Here's another thing we're loath to do: limit the number of clients you're dealing with and be selective on your client intake. And I know that we always say this, but this is achievable. You can do more for fewer number of clients. This is not a game where whoever has the most clients wins. Decrease the number of clients you have, and never forget the 90-10 principle, which is that 90% of your aggravation is based on 10% of the clientele you have. Get rid of that 10%. Bad clients are almost certainly more likely to increase your malpractice exposure, even when you do everything perfect. So we know those little steps will achieve a lot for us, and I would encourage everybody to continue to focus on that and to remind remind ourselves of that mantra: fewer clients, fewer bad clients. Alan?
Well, I think that's a great point about thinking about our law practices, because we're told to go out and market, and we're told to get new clients in, and I think you get to a point where you've got plenty of clients and you really ought to spend time working with the files you already have, reaching back out to clients and reminding them it's been a period of years since they've updated their will. On the issue of malpractice concerns, we've all heard and talked at various programs about our clients living longer, and it's very unscientific in my little narrow window of an estate planning practice, but clearly it's happening in my practice, and I know it's happening around the country, and it is an incredible challenge. We're not mental health experts, we're not doctors. We do the best we can to determine that the client understands what they're doing and they're not being unduly influenced by a family member. But it is extremely difficult as the clients get into the late 80s and the 90s and even the hundreds, and they become isolated, either because physically they can't get around like they once did, or they're starting to slow down mentally. And just because someone has an early diagnosis of something like Alzheimer's, that doesn't mean they can't update their estate plan. But what if someone is influencing them, and they're processing information in a way that's totally different from the 40 years that you've known that client? It's a very troubling area. I don't think the rule of ethics are really clear on what our duties and responsibilities are. But it's very, very challenging to go from seeing a client every couple of years and having very detailed back and forth with the clients about what they want, to all of a sudden the client starts drifting out away from a regular relationship of trying to understand what we can do or should do relative to that client, their estate planning, their financial assets.
Let me just give you a couple of stats because I found them. I didn't have them handy before. There was a Ames and Go study in 2022. The largest number of malpractice claims stemmed from 3 key practice areas. 3. And guess what number 1 was? Trust and estates. The ABA in 2020, Standing Committee on Lawyer Professional Liability, publishes a profile of legal malpractice claims every 4 years. The percentage of claims involving payouts of $2 million or more substantially on the rise. So this is really, really significant. And I think one of the comments that Lou made is it's really hard to do. Nobody likes to fire a client or not take a new client. But I think we kind of all know the red flags. We just can't get caught up in trying to help everybody because we like to help people, or we want to get billing, so we're taking on new clients. You got to be very discerning. And if you can do it before they become a client, the ethics rules really don't apply to not taking a new prospect. They only apply and create some concerns once somebody becomes a client. But it's hard to do. It's hard to do. Next topic, aging clients. Our clients are aging. How does that change what we do, and how's that going to change the future of the practice?
I'm trying to age faster than my clients so that I can be gone.
You look like you're almost up to age 35, Lou.
Yeah, thanks. What do you think, Jonathan, on the aging?
Well, I mean, the fact of the matter is that, Americans are getting older. More than 10,000 people every day in the United States reach the age of 65. More and more as a percentage of the population is getting old. And that raises all sorts of issues, such as, well, you want them to do estate planning, but the client says, I've got to maintain enough to take care of myself. And that's a dilemma that you have to share with your client. That's a real problem. Second is people, I think we are pretty close to a situation where longevity may be significantly extended. I think this will have to do in part with where we started, which is artificial intelligence. But that's something that we really need to consider in counseling people. But it also means that understanding is going to be more difficult for those people unless they're able to eliminate, the almost certain fact that your mental capacities will decline. And that's going to raise problems for the client, and it raises problems for you as well. But again, keep in mind that no matter what the client says that he or she wants to do, they have to consider their own needs first, not those of their children or grandchildren or boyfriend or girlfriend. You've got to make sure that they don't get rid of what they need to live that full lifestyle, which they really need and deserve.
Actually, Alan, before you comment, I have a question for you and for Marty on this aging issue. As we as estate planners age, in all seriousness, our value to our clients, increases as we get older. We've been with them. We have knowledge of their families. They need us here when they're not here. What's our exit as we age, as our faculties become a little bit less, or as we're tired of worrying about malpractice? What's our exit game? Because we're a profession that's the exact reverse of every other profession. We stay around for a long time.
Lou, that's, I think, very observant of you. And I've known some people who at one time were older than I am. They've all kind of died off. But they would have clients who said, you cannot retire. I count on you. You've been representing me for 20, 30, 40 years. You can't retire. I want you to be the guiding principle. And they want you also for their children and grandchildren. So that's another problem that we face. Of course, some firms, like my firm, you're kicked out at a certain age and you're no longer allowed to practice in the field. So if you're at a firm like mine, it's not a problem. But if you're at a more, let's just say a different firm, Alan, I'm going to guess that you, and Lou, I'm going to guess you don't have a maximum retirement age. So if you don't, what do your partners do when they think that you're maybe not as sharp as you used to be?
Yeah, and I think it's a great challenge, and the answer to me is that we need to have younger team members that the clients get to know, who become the technicians, and we can hang around as the family counselor, and that's our real value. They trust us, they know us, we know the family, and they remember when I first started practicing and was learning from great lawyers that have been practicing 30 years. We could say the exact same thing, but there would be no value placed on the new lawyer's statement. And it was words from on high from the trusted older advisor. We can play important roles and help our clients think through things and implement good plans, but we need to bring in younger team members that are staying current on the law and have fresh energy and sharp knives to address these problems.
It's a very interesting issue. I've made a concerted effort to train and educate an associate who's going to become a partner within a few months, so that's part of my transition. What I've done, which I don't think a lot of people are going to be comfortable doing because of the way law firms provide compensation, is I've made a concerted effort to have him on most client emails. I push clients to talk to him because that's the way to really get him the training and the experience, not just technically, but interacting with clients. And it's the way to get clients comfortable working with him so that they know he's there. The problem is that if compensation is based on how much billing did you bring in and how many hours did you bill, even if we're comfortable as we get older doing less billing and making less because of that, what happens to the revenue stream that's solely compensation based on origination? We, as a profession, and I may be wrong, but I don't think many, if any, firms really provide a compensation component for things like wisdom and aging and guidance, mentoring younger associates. We've talked about alternative billing in the profession. We need to probably also talk about alternative compensation structures, because if you transition your clients, whose billing is it? What happens to that? And what happens to the next referral? So I think it's a little complicated. The malpractice issue deeply worries me, and I really feel the profession really needs to reevaluate permitting lawyers to limit their liability. Every other professional can do it, and we dig into things that are complicated. There's no answers for it. When you get into the esoteric estate tax planning on a $1 billion estate, how much law is there really? Do we really know if adapt or hybrid adapt or spat really works? How much case law is on any of this? And yet we're trying to help clients. I think we apprise clients of the risks and the uncertainties, and clients can make the best decision they can. But with so much unknown, why are we as a profession forcing lawyers to not limit liability? I don't understand it.
Well, hey, Marty, you said something that I think is completely sage, and I want to pivot off of that, which is as you try to transit, and Alan, Jonathan, your comments are right on point, obviously, as well. When we're trying to figure out the exit ramp and where we're going to be as older professionals, I think we have to say the following. When I reach age X, and whatever that is, I'm going to do the following. On the left-hand side, I'm going to say the quality of my life matters more than anything else. And the two things that are impeding on that quality of life are on the right side, which are ego and money. And I am going to focus on decreasing my ego and decreasing the amount of money I make to impact on the quality of life. So when I transition clients to other attorneys, I hope they get more. I hope the firm gets more. I'm going to get less. We have to make a conscious effort to do that, or we're going to be chasing our tail. But we'll come to quality of life, I guess, in a few minutes. At a certain age, you have to give priority to that versus some other factors that are not helping you. So I like what you said. I mean, you're going to trade off things that have been important to building your practice, motivations to building your practice, and motivations to making you a better attorney. You're going to have to trade that off for quality of life at that point.
I think it's very hard for a lot of people to do.
Everybody.
But that's the philosophical, that we all have to go through. By the way, I think the number approximately ABA membership, I think something like 30% are age 60 and over. I remember digging around their website to find the data, and it's a very significant number. So,
well, Marty, ours is the only profession where people continue to practice into advanced ages, let's say 80 and above. In fact, as a very young lawyer, I was invited to join a very well-known firm in Manhattan, and I was young. I'd only been practicing for 2 years. It was a real honor for me. But when I went around and met the senior most partners, all of whom had the corner offices, they were all in their 80s. And they held on for all the reasons that Lou was indicating. And it just doesn't make sense. But, how often do you run into a physician who's practicing in her 70s and 80s? Virtually none. And if you work for an institution, even though, you may or may not be able to discriminate on the basis of age, you'll find very few people who are going to be in their senior years, late 60s and 70s, whereas in the law, it continues unabated to continue. And how that ends, I'm not sure, except I think that Lou is absolutely correct. You really need to make plans for that, for yourself and for your colleagues. But as Lou said, one of the factors on the other side is going to be money. You're making a lot of money. And if you retire, you may not get that stream from the law firm, or it will be greatly reduced.
should I tell you what I've been doing, Lou?
Yes.
When we talk sometimes, I may be sitting with my RV in a national park looking at a whole lot of trees, or I could be at a distillery in somewhere in Wisconsin or Minnesota, and that's just fine.
Yeah, but
And
should you be practicing, Marty?
At the distillery,
Well,
makes
what I'm saying is when
creative.
you reach an advanced age, of course, being 49 years old, you've got many, many decades to go. But at
I
what point
wish.
will you say, even though I love what I do and I know my clients appreciate me and I know I really feel terrific about what I'm doing, I still think I add a lot to the equation. At what point do you say I really need to hang up my guns?
hey,
Well,
Jonathan, I'm going to add. Oh, go ahead.
no, I was
Go
going
ahead.
to say I'm cutting back. I'm still practicing because I love it and I want to stay vital. But I've cut back, and just like Lou described, I've reprioritized. And I've also said to my associate to be partner many times, when I start to not make sense or I'm losing it, you tell me, you get in my face and tell me it's time to go.
Well, my dear friend Mitchell Gans and I have that agreement that when he starts to fade, I will tell him, and he's agreed that when I start to fade, he'll tell me. Except he said, wait a minute, Jonathan, if you come to me and tell me I'm fading, I'm going to turn around and say, no, it's you, it's not me.
So I'm going to suggest something that's controversial and really hard to do, Jonathan, to your point, and that is, you really want to be done like with an athletic activity when you're at the top of your game, not when you're at the bottom. Same with this profession. You want to be done when you're at a high level practitioner, not when you're sinking into the abyss. And it's really hard to do. And I just think it's the best advice possible if you can make it happen. So just a thought.
Let's go on to our next topic, and I'm going to introduce it real quick. And I don't know that it's going to need much time, but it to me, when we look at the future of the profession, this is a concern to me. And I called it in our little agenda information overload. Now, much of my information overload, I'm going to blame on the guy Jonathan up here on the screen, because when the Corporate Transparency Act came out, he was gung ho that we're going to analyze this, we're going to do speeches and articles, and we're going to explain it, we're going to learn it. And we did. When the FTC came out with its non-compete rule, we jumped all over that. The FTC rule and ancillary pronouncements were probably close to 500 pages. The Corporate Transparency Act, if you add up all the guidance and the various guides and everything they had and the FAQs, probably another 500 pages. The Loper decision changes everything. I can't even imagine, and maybe one of you have a guess just for the fun of it, how many pages of regulations have been issued and proposed in final form for the Secure Act? Like 1,000? More? It just, how can anybody keep up with this? And when you combine this with the fact of unlimited liability, cybersecurity issues, all the nuanced human interactions we have to have, I think this is really becoming beyond a challenge. It's becoming problematic for so many of us. How can you keep current with everything? And that's why when I hear that a financial advisor who's really good as a wealth advisor is also doing income tax planning and estate planning, how can you do it? You can't do it at this level. But what do we do to cope?
Well, remember, Marty, that many financial advisors are interested in one thing, and that is making more money. And there are many institutions where if you don't produce, you're not going to be paid well. You may not be able to keep your job. So there's pressure coming at that to continue to stay in the game and continue to say to people you meet, oh, I can take care of that. My firm can take care of that, even if you're not in the best position to do that, because you don't want the ability for someone to say, hey, we've got someone else who can do that. You're not that important anymore.
Alan, Lou, how do we cope with the massive amounts of new legislation, regulation? And it's not just tax laws. Look at all the other laws that change on a regular basis.
Have a lot of young people that know it because it's not possible, Marty. I don't have an answer for how any of the four of us on this call can stay up with all the changes. but the more people that you surround you that you can rely on, I think the better.
That doesn't speak well for smaller firms.
No, it's very hard.
Well, the
Yeah.
one thing, getting back to where we started, which is artificial intelligence, I think artificial intelligence can somehow bridge the gap for many people. Like, how should I set up the pension benefits or the IRA benefits for this particular client? And, you can get Natalie Choate's book and read that, but I think that, someday we'll be able to put it in and the system will come out with recommendations and tell you why. I don't think we're that far away from doing that.
Alan, any thoughts?
One thing I think about is in our traditional engagement letter for estate planning services. You take the suggested ACTEC, the template ACTEC letter. Where does it say in that letter that I'm a Georgia law practitioner and I have no duty to explore a Nevada trust and call Peak up and set up trust up there for a client that is getting remarried or may have professional malpractice exposure? It scares me to death because there are so many issues out there, and it's not humanly possible to stay on top of all of those. And so, can we look at our engagement letters and narrow what services we're expected to provide, what we're supposed to analyze? With Georgia still has a state income tax. Our neighbors in Tennessee and Florida don't. Our neighbors in Tennessee may have better asset protection than Georgia. Certainly Nevada and some other states do. But how can you in a small or medium-sized practice in whatever state you practice keep up with all of that? And can you in your engagement letters tell them what you're going to advise them on federal tax law and Georgia will and trust law, and that's what we're analyzing? I don't know. It's a real challenge. I think and when I first started practicing, I knew almost all of my clients. I had gone to school with their kids or whatever, was in a Rotary Club with them. But when you start dealing with folks that you don't know, I think your exposure to malpractice liability goes up. And as we said, having a lot of clients may be a bad situation, because you can't give those clients the time they need. And so I'm trying to work more, working with clients that I know or I have a great relationship with their advisor and know what the team is going to look like. And they likely will follow advice and maybe they will pay the bill when you send them a bill. Have fewer clients, try to go deeper with them. I think that will reduce the exposure for malpractice risk. I think it will make my day-to-day job more enjoyable. And I think that has a direct relationship to health and longevity in the practice.
I think one of the ways to try to address the impossible, echoing Alan's comments, impossible task of keeping current with all the myriads of changes is we try zealously, strong word, to collaborate. I want the wealth advisor involved. I want the accountant involved. I want co-counsel involved if it's a Nevada trust in Nevada. I want maybe Lou involved or Jonathan involved if it's a large estate with complex issues, because we've all seen different things. So I think broader collaboration is really one way to help address what is really an impossible problem. And that's certainly, as the smaller your firm is, the more collaboration you need, because you don't have a partner down the hall that can advise you on the real estate issues. So we push for collaboration. I'm not sure what else to do with it. Let's go on to our next topic, and I'm going to just make a few quick comments. If you guys want to comment, that's fine. If not, I think we only have one more topic or two to wrap up. Addiction and mental health issues. Lawyers are in the top 11 professions with the highest suicide rates. Lawyers have unusually high rates of depression, anxiety, and substance abuse. A 2023 ALM study said that 60% of lawyers felt overwhelmed and exhausted. So I feel overwhelmed and exhausted. Which two of you also feel overwhelmed and exhausted? Who doesn't? 75% said their work environment contributed to their mental health issues, and the top reason being billable hour pressure and the pace of work. These are tough studies. An ABA Betty Ford study, and it was a few years ago, and I've seen much higher numbers, said 21% of lawyers self-identify as problem drinkers. But it's interesting when you ask lawyers questions like, do you have more than X number of drinks? Does the drinking ever affect your ability to do such and such? Specific questions, not a broad question, are you a problem drinker? In some of the recent studies I've seen, some of the numbers get as high as 50 to 70%. Very bad. I think this is an issue for our profession, and I don't know what the answers are. Any comments or thoughts?
Brief one. I've devoted the last 15 years to this topic, and I would recommend you, Marty, consider this as a separate seminar for the group, because there are an amazing number of steps that we can take as a profession and individually and through firms that will address, and I personally think solve, most of these problems. But
I just did a series of 2 webinars on mental health issues. In the second webinar, I barely spoke. It was incredibly powerful. There's an estate planner that died by suicide, and his widow, because she wanted to help other people, spoke on the program. It was incredibly powerful and moving. But if you have answers that are practical that people can take, we should do a follow-up webinar, Lou, and you're going to be on it.
I would be happy to do that. I'm very passionate about this. We do such a great job for our clients. I do not know why we're not doing great jobs for ourselves. I know why. We're driven to help others, not ourselves. But we have to stop that.
Great point. Great point. I think as a profession, we have to talk more about it, because the first step in dealing with the problem is acknowledging it. And Lou, let's definitely do a follow-up. Any comments, Alan or Jonathan? So the last topic we had, which I don't have any comments on, are fees. Do any of you want to make any comments about the future of billing in the profession? And then I think we're done.
Continue to keep this as a focal area for all of us. We need to do better. I think our value to our clients is undercompensated. I don't care where you are or what you're charging. We are second to physicians, the most important people in their lives. And I think we need to value ourselves that way. We need better billing practices, and just keep thinking about it.
Any general suggestions people should be thinking about other than billing by the hour?
Yeah, project based.
Marty, when you take a look at the ABI guidelines, there are 8 factors which are listed to determine your fee. But, it's very, very hard to do. Most firms, when you have more than a few lawyers, will insist upon hourly billing. And it's very, very difficult to get over that. I mean, you can come out with, fixed package prices. We'll do a will for you, we'll do a rev trust, we'll do a power of attorney, we'll do a healthcare proxy, all for, $29.95, or whatever the going rate is. But of course, that means that you're going to want to put in the fewest number of hours for your client. It's a real problem for the profession, and it's a real problem for clients as well.
Hey, Jonathan, there is one thing that we're forgetting to do for our clients on the billing, which is the number one item in client satisfaction is fairness in billing. And we're forgetting to demonstrate to them the value that they're getting in the process. If you protect assets from the evil in-laws, what Alan had mentioned earlier, that's actually more valuable to a lot of our clients than the estate tax protection, but we sometimes gloss over that in a 30-second discussion with them. We have to demonstrate the tremendous value we provide, then they will view our bills as fair, and that will go a long way towards solving a lot of the billing items that concerns we have.
How do you,
Short
how
version.
would
I
you go
agree
about
with
that?
that. I agree with that, but I also know that, when I represented a very, very wealthy man from the West Coast who did a lot of work, and I sent him a bill for 100,000, which was exactly what I estimated and exactly the time that we put in. And he wrote back and he said, Jonathan, I realize you're a very talented lawyer, and but all of this was for my kids. What did I get out of this? And I wrote back and I said, well, how do you think your mother feels? Because I was able to save several $1,000,000 for him as the inheritor of his mother's wealth. And he wrote back a note saying, touche. But remember, it's like the difference in when you do elder law, when someone comes in and says, my husband can no longer toilet himself or feed himself. And the wife says, well, what do I do? And the lawyer who does this elder law work says, well, guess what? If we don't do something when he dies, the state is going to take, 90% of what you've got. But if we do some planning, we can keep, 90% for you. Do you want to do that? And of course, they say yes, and they get hugs and kisses, and they're invited to all of the, birthday parties and bar mitzvahs and all the holiday stuff, and they just love them. But when you're doing something for someone else, which our estate planning traditionally has said, we are doing this so your family can have more in the way of wealth, it becomes kind of lost in the shuffle about what that client is really getting from your efforts. And I don't know how we change that, but it's important that people understand that it's not just what we're doing to get their descendants more money, it's also to make sure that they're doing the right thing.
Alan?
Well, I thought a lot about the fact that in a firm like ours, estate planning is one of the few areas of our practice where an individual pulls out their personal checkbook and writes the check. In corporate matters, it's the corporate checkbook, or in litigation, oftentimes it's an insurance company that's writing the check. In a real estate closing, the money goes through the firm account and the legal fees are taken out, and then the client gets a check. But ours is one of the few areas where we send them a bill and they pull their own checkbook out. And Lou has talked and written for years about how to prepare bills that convey value, and whether you should bill one time at the end of the engagement or whether you should bill all along. Because I've gone back and forth over the years. I think it was your material, Lou, that talked about perhaps a client would rather get one bill than multiple bills. Let them feel the pain one time, I think you said. And I'm starting to think about that. That may be the way to do it. Have real clear information on the front end of what we're going to do and what it might cost. And if it's going to cost more, let them know early. But perhaps sending them that single bill with a good explanation of value is the way to do it. We are really stuck in multi-practice firms where, since the late 60s, we've become accustomed to hourly rate billing as much to monitor the production of the people in the office as anything. It's a terrible gauge of value. If you're doing a simple estate plan for someone with $1 million, that hour doesn't have the same, I mean, in some ways it does, but it doesn't require the same abilities. It doesn't have the same liability exposure of doing an estate plan for a family that's got $100 million. And I'm trying to get more and more away from hourly billing, but I'm struggling because almost every time I quote a fee, it woefully underprices what we end up doing for the client. So I've got to suggest broader ranges, tell them the factors. Last time it's the client picking up, putting it down, picking up, putting it down, waiting 6 months to get back with us. That adds to the fee. But I want to aspire to have more value billing, because the money that we invest in technology and providing protections against cybersecurity and training and mentoring for everybody that listens to this video is taking time out of their practice. how do you recoup the value that you've invested in these things? It's rarely from hourly rate billing. And if you go tell your individual clients that I'm going to charge $750 an hour, they don't know how to understand and process that.
Well said.
So any other topics, or I think we can wrap it up. So why don't we just go in the reverse order? Jonathan, any summation comments?
Well, Marty, I'm going to again kind of end where we started, which is that the profession is changing very, very rapidly. I think artificial intelligence is going to have a huge impact, but it's going to be more gradual than immediate over the next few years. And that's something that should be kept in mind, but we've all got to be aware that the practice will change, but there are great opportunities, at least today, to do great things for our clients and for our firms.
Alan?
This is a wonderful profession. There are fewer and fewer people going into it. It's a necessary profession. People need our services. I think to be successful and to preserve our health, be honest with yourself and choose clients that you think you'll have a good relationship with. Choose clients that understand the value and are willing to pay the bill and also willing to follow your advice. More clients doesn't create a healthier legal practice, and I don't think it creates a healthier lawyer. But we've got all these tools out there, technology, referral sources. AI, I think, is going to be an exciting development. We need to embrace these opportunities, but in the end, we need to look at what our areas of interest are, areas of expertise are, and find a way forward without trying to be everything to everybody.
Lou?
I am so grateful to be in this profession. I'm grateful to have incredible colleagues like Jonathan, Alan, Marty, everybody on the phone. This profession's rocking and rolling for the next 20 years. And as we like to say in hockey, my major advice is just keep your head on a swivel here, eyes open, and it'll be a good journey.
I can't think of a profession that could be more rewarding. You get to help people, you get incredible intellectual challenge, and what we know makes us the highlight of every cocktail party we go to. I mean, who doesn't want to hear about GST tax? Let me just make an interesting, at least to me, interesting observation. Jonathan, and I didn't know who he was back then other than it was Jonathan, at Heckerling in 2010, 2011, something like that, spoke about the future of the profession. And a lot of the fundamental key points that he was making, you're going paperless. We got to go paperless. We're not going to need the office space that we used to have. You're going to have meetings online. He talked about all of that. And that's all come to pass. It's interesting to me how different some of the topics about the future of the profession are now because things have evolved. I think we've kind of accepted paperless, cloud-based, et cetera, but now we got cybersecurity, right? Now we have worse information overload, and we probably thought we had it then, but it was nothing compared to what we face now. So it's fascinating to me how in the, what was that, 15 years ago, that the future and the issues and the challenges we face are so different. And it's what keeps it exciting. So thank you everyone for joining me. I feel honored to have had Jonathan and Alan and Lou. I was really looking forward to this, and I think it was incredibly informative. So I hope you all found it that way as well. Thank you all for joining me on the panel, and thank you all for attending.